NGO Women and Men Against Child Abuse wants Justice and Correctional Services Minister Ronald Lamola to take disciplinary action against the Parole Board, which earlier sanctioned the release of disgraced tennis star Bob Hewitt. Following an outcry from the victims, among others, the decision is now being reviewed. In 2015, Hewitt was sentenced to 6 years in prison. Hewitt, now 79, was convicted of the rape of 2 young women. He was also found guilty of sexually assaulting another who he coached in the 80s and 90s. Last week, the lawyer of one of Hewitt's victims was informed about his pending release. The review comes in the wake of repeated calls for harsher punishment for perpetrators of violence against women and children. Well, for more on this story, we cross to our Pretoria studios where Chrispin Phiri, the spokesman for the Ministry of Justice and Correctional Services, is standing by. Thanks very much for joining us, Mr. Phiri. So why did the minister decide that this case should indeed be reviewed?
Well, thank you for having me. One of the things that the minister did learn through at least a couple of media reports and as well as through confirmation from one of the victims that unfortunately in this process the victims of the offender, Mr. Hewitt, were not adequately consulted and were not enabled to give representations on the matter. And as a result, the minister felt that the law and its prescripts were not adequately followed, and that gives them the right to institute a review in the matter.
So basically, how long can we expect that review process to take place? It's a matter of just consulting the victims, is that right?
It's more wider than that. We need to understand why there was a lapse in the system, because it is a legislative prescript that the victims must be consulted. So it's not a matter of just simply going and consulting the victims, but from the minister's perspective as well, he would like an adequate explanation as to why the victims were not consulted in the first place. And it is quite concerning. We think that if this has happened in a high-profile case, it is very plausible that it has happened in other matters which involve Sbongile or a Nomsa in Matatiel or a Sbongile in Zanin. So we think that this really calls for us to look at the system more widely and to understand if there are lapses in the system or this is an isolated incident.
Generally speaking, what is the minister's view about people serving basically a third of their sentence? I mean, if you have committed a crime and you've been convicted and you've been sentenced, why on earth don't you serve that full term? Because at the end of the day, your victim, had to be at the wrath of whatever you did to them.
So one of the reasons why a victim has to be consulted in the parole process is because we have a restorative justice system. So even perpetrators can be rehabilitated. And the parole process is to assess whether an inmate has been sufficiently rehabilitated and whether the inmate himself or herself understands the effect of the offense on society. And having them meet with the victim or consult with the victim on their offense and whether they're eligible for parole is part of that process. In essence, our correctional facilities are exactly that. Correctional facilities. They're not meant to store away people into perpetuity. And we have to be able to assess at some point whether the rehabilitative process that we have put into the system actually works. And this parole process enables us to do so.
Is there a chance that Mr. Hewitt's age may enable him to be able to put in a claim that he's no longer harmful to society because he's old?
As I understand it, that may have been what Mr. Hewitt had pleaded in the first place. So the justice who sentenced him may have considered that as part of the sentencing. But one of the things that we have to look at is whether he understands the harm and the effect of his conduct on society and the victims. And that is the test, ultimately, that we should look at when granting someone parole, amongst other things.
And just lastly, before I let you go, Chrispin, the issue of life imprisonment. If someone gets a life sentence, does life mean life? Do they get a life sentence, or can they come out, a third way through their sentence?
Life does mean life. However, one would be eligible for parole after 25 years of serving that sentence. And there again, you have to show sufficient cause that there's been a certain level of rehabilitation. But in certain instances, I know for a fact that just on Thursday, an individual was prosecuted to life, was rather convicted to life sentence, and then on top of that, 50 years was added in that sentence. So that means that that person would not be eligible for parole even after they have served 25 years. In some instances, people are given 4 life sentences, which means that those have to serve concurrently, and that also then means that an individual at some stage would not be eligible for life. But broadly speaking, life does mean life, and it really does depend on the sentence that's given by the judicial officer.
All right then, Chrispin Phiri, thank you very much, sir, for your time. He's a spokesman at the Justice and Correctional Department.